Learned counsel opposed the appearance of Honorable James Orengo, senior counsel, who is the serving governor of Siaya County and therefore a state officer. Learned counsel submitted that the Honorable James Orengo is a full-time serving state officer, as per Article 260 of the Constitution, as read together with Section 26, subsection 2 of the Leadership and Integrity Act, which bars a full-time state officer from engaging in any other gainful employment. Counsel further submitted that it would be prejudicial to the Deputy President if the Senate allowed Honorable James Orengo to represent the National Assembly in these proceedings. Counsel drew the attention of the Senate to the President said in the matter of the proposed impeachment of the Deputy Governor of Kingi County, Honorable Richard Monda, in which a decision was taken to bar Honorable Sylvanus Osoro, Majority Whip of the National Assembly and Member of Assembly for South Mugirango in Kingi County, from appearing as counsel for the Kingi County Assembly. In his submission, counsel cited Article 77 of the Constitution and Section 26 of the Leadership and Integrity Act, as well as the decision of the High Court in Office of the Director of Public Prosecutions versus Orengo, Manduku, and two others, interested parties, Constitutional Petition 204 of 2019-2021, KHC 456 KLR 27 April of 2021, where Honorable Justice Ogola found and ruled that the continued representation of the first interested party, Mr. Manduku, by the respondent, Honorable James Orengo, as then was, or any other state officer is against the spirit of Chapter 6 of the Constitution for failing to conform to the mandatory provisions of the Leadership and Integrity Act. The judge ruled that in that case, there was an inescapable conclusion of conflict of interest in Senator Orengo representing the petitioner, highlighted by the fact that the interested party, Mr. Manduku, the managing director of KPA, may at one time be summoned to appear before a committee of the Senate to answer to some of the matters that the petitioner was being investigated on. In response, Mr. Eric Gumbo, learned counsel for the National Assembly, submitted that Article 77 of the Constitution is the primary law that restricts activities of state officers, and it specifically prohibits a state officer from engaging in any other gainful employment. Counsel further relied on Section 26 of the Leadership and Integrity Act, which he submitted has defined gainful employment, and in this matter, no evidence had been laid that the Honorable James Orengo was participating in gainful employment. Counsel referred the Senate to the decision of the High Court in Busia Election Petition number 3 of 2013, where the court interpreted Article 77 of the Constitution and Section 26 of the Leadership and Integrity Act 2012. Counsel also cited the decision of the court in the Mwilu case, which defined conflict as where one is confronted by two different interests, where one is competing with the other. Learned counsel for the National Assembly submitted further that no prejudice has been demonstrated that would arise or be occasioned to the Deputy President by the participation of Honorable James Orengo in these proceedings. Learned counsel for the National Assembly sought to distinguish the decision by Honorable Justice Ogola in the Office of the Director of Public Prosecution versus Orengo on the basis that this case turned on the fact that Honorable James Orengo was at that time a sitting senator before whom the matters in respect of which his client was charged could potentially come for adjudication in the Senate, and that no possibility exists into the current matter with Honorable James Orengo as the governor of Siaya County. In his rejoinder, Mr. Njiru, learned counsel, submitted that Honorable Orengo is the serving governor of Siaya County and therefore a full-time state officer, and by that fact alone is a violation of Article 77 of the Constitution. Further, Mr. Njiru submitted that prejudice is not one of the applicable tests under Article 77 and Section 26 of the Leadership and Integrity Act, but that the only applicable test is whether or not Honorable Orengo is engaged in gainful employment. He argued that the National Assembly had not proved that Senator Orengo was providing pro bono services in this matter. Honorable Senators, Article 77(1) of the Constitution provides that a full-time state officer shall not participate in any other gainful employment. Further, Section 26 of the Leadership and Integrity Act provides that a full-time state officer shall not participate in any other gainful employment, while Section 26(2) defines gainful employment as work that a person can pursue and perform for money or other form of compensation or remuneration which is inherently incompatible with the responsibility of the state office or which results in the impairment of the judgment of the state officer in the execution of the function of the state office or results in conflict of interest in terms of Section 16. Having considered the matter, it is important to state that a state officer must inspire confidence. However, it is trite law that he who asserts must prove. In this regard, I wish to observe that the learned counsel for the Deputy President did not adduce evidence to prove indeed and demonstrate that the allegation of gainful employment. In fact, it is somewhat surprising that counsel attempted to shift the onus of proving gainful employment to the National Assembly. That argument is untenable. As to the ruling of the Senate, that barred Honorable Osoro from appearing for the County Assembly of Kisii in the impeachment proceeding of the Deputy Governor of Kisii County Government, it is clear that what was objectionable was that Honorable Osoro was not only a member of Parliament for a constituency in the same county whose Deputy Governor's impeachment was an issue, but also a high-ranking member of the leadership of the National Assembly, and by extension, of the same Parliament before which the impeachment was being undertaken. It was ruled that in these circumstances, it was clear that in the minds of the public, the fine distinctions of the bicameral Parliament would be lost, and their confidence in the impeachment process would entirely be undermined. In the same breath, as rightfully contended by counsel for the Deputy President, it is true that in both Article 77 of the Constitution and Section 26 of the Leadership and Integrity Act, no test of prejudice is expressly provided for. It therefore follows that both the contention of the counsel for the Deputy President that his side will be prejudiced by the appearance of Senior Counsel James Orengo and the rebuttal by the National Assembly that no prejudice will be occasions are moot. Honorable Senators, ladies and gentlemen, having analyzed the preliminary objection raised and for the reason I have given, the preliminary objection raised on the appearance for the National Assembly by Senior Counsel James Orengo is hereby dismissed. We will now hear the response on the second objection raised by the counsel for the Deputy President. Counsel, you have 5 minutes to do that.
Thank you very much, Mr. Speaker, sir. I'll endeavor to respond to the preliminary objection within the time allowed to us. Mr. Speaker, sir, the objection was premised on Rule 20 governing the proceedings that are currently before this House. The rule reads that in presenting its evidence, the Assembly shall not introduce any new evidence that was not a part of the allegations against the President by the National Assembly as forwarded by the Speaker to the National Assembly to the Speaker of the Senate.
Mr. Speaker, sir, with your kind permission, I was just seeking your guidance whether I need to do a rejoinder because I'm the one who had moved the Assembly in respect to the...
Very well. You may go ahead as I put my thoughts together.
Thank you very kindly, Mr. Speaker, sir. In response to what my learned friend has raised, the application or the objection had nothing to do with the public participation as cited. We simply raised an objection that goes to the roots of the ability to enjoy proceedings that will appear fair to all parties. My objection was premised on the non-derogable right to a fair hearing. Counsel has addressed you that the deponent of that affidavit, one Jomo, was responding to the Deputy President's response. There's nothing that can be far from the truth. And this is a witness who is being brought to panel beat or to attempt to panel beat the case for the National Assembly. The question and the test, Mr. Speaker, sir, is, shall we suffer prejudice? Shall our rights be deemed to have been held? And that is the non-derogable right to a fair hearing. This is not a witness who was before the National Assembly. Where is the source of this information in the document that was submitted to this House by the Speaker of the National Assembly? Where does it sit? Who sits to suffer prejudice if the same is admitted? Is it a state organ or an individual in the name of the Deputy President of the Republic of Kenya? We urge you to uphold our ruling and justice be seen to be done, even to the people following these proceedings. I am most obliged.
Now, Honorable Senators, the second preliminary objection raised by the Counsel for the Deputy President was that the following documents, which were submitted by the National Assembly on Monday, the 14th of October 2024, were not part of the bundle of documents of the National Assembly that was served on the Deputy President on Wednesday, the 9th of October 2024. These are an affidavit signed by Mr. Peterson Jomo Mushira, and B, the document of the National Assembly marked as Volume 8A, responses from various government agencies. Counsel for the Deputy President stated that these documents prejudiced the Deputy President's case and amounted to a trial by ambush by the National Assembly. Counsel urged the Senate to bar the introduction of these two documents as they constitute new evidence in terms of Rule 20 of Part 1 of the second schedule to the Senate Standing Orders. Counsel for the National Assembly opposed the preliminary objection raised by the Counsel for the Deputy President. Honorable Senators, ladies and gentlemen, Rule 20 of Part 1 of the second schedule to the Senate Standing Orders provides, and I quote, "In presenting its evidence, the Assembly shall not introduce any new evidence that was not part of the allegations against the President by the National Assembly, as forwarded by the Speaker of the National Assembly to the Speaker of the Senate." As I indicated in my earlier communication, by a letter dated 8th of October 2024, I received a bundle of documents and records of proceedings in the National Assembly in this matter. Thereafter, on the 9th of October 2024, pursuant to Rule 6 and 7 of Part 1 of the second schedule to the Senate Standing Orders, the Office of the Clerk of the Senate sent invitations to appear to both parties. The parties were required, amongst other things, to specify any other evidence to be relied on this matter. I will repeat that. The parties were required, amongst other things, to specify any other evidence to be relied on in this matter. In response to this invitation, on Monday, 14th of October 2024, the National Assembly filed further documentation. Having analyzed the documentation submitted against the grounds for the proposed impeachment, I find that the documents objected to constitute evidence in support of the allegations already made in the impeachment motion as received from the National Assembly. It is noteworthy that the parties were instructed when sending responses to indicate any other evidence to be relied on. Accordingly, the documents being referred to do not constitute new evidence, but form evidence in support of an allegation which was already made. That is why Rules 6 and 7 of the Rules of Procedure permit the Senate to receive witness statements, list of witnesses to be invited by and any other evidence to buttress an allegation already made. What is not allowed is to introduce new allegations or to introduce any evidence that is extraneous to the allegations made in an impeachment motion. In the event, it is my considered view that the affidavit and document marked as Volume 8A being referred to fall within the permissible documents of our Rules of Procedure. I therefore rule that the objection is hereby dismissed. Now, Honorable Senators, having dispensed with the preliminary matters in this particular hearing, we will now move to hear the, yes, Counsel for the National Assembly.
Mr. Speaker, sir, with your very kind permission and indulgence, we as well, on the part of the National Assembly, had two quick preliminary issues which we wanted to draw your attention to, Mr. Speaker, sir. There are quick housekeeping issues. If you permit me just in 2 minutes, I may be able to draw them to your attention.
Exactly 2 minutes.
Most obliged, Mr. Speaker, sir. Mr. Speaker, sir, the first one is in relation to the bundle of documents that we have filed before this House to help it determine the matter that is before it. In particular, we have one of our documents, or one of our volumes, volume 4, as a document presented before this court, before this Honorable House. Mr. Speaker, sir, when we were perusing our documents earlier today, actually yesterday, we did realize that one of the documents in that volume 4, running from page 135 to 140, appears to have been inadvertently copied just on one part. In other words, in the course of a printing, we missed out the witness. I am most obliged, Mr. Speaker, sir.
Counsel for the Deputy President, what say you?
Mheshimiwa Speaker, Honorable Senators, with regard to the first request, which I understand to mean that when they were photocopying, some pages were left, we are going to examine that and see what was served on us and what those pages that are now being introduced contain. With regard to summons to ask individuals from the Anti-Corruption Commission to come and give evidence, Mheshimiwa Speaker, honorable members, we draw your attention to Article 50 of the Constitution, which is a fulcrum of a fair trial. And this Honorable House is executing a quasi-judicial function of the most weighty nature regarding the removal from office of the Deputy President of the Republic of Kenya, elected by the people of Kenya. Nothing would be more prejudicial than to call witnesses whose statements or affidavits we have not seen. Nothing would be more prejudicial than to call witnesses whose statements or affidavits we have not seen. The whole purpose of affidavits and witness statements is to enable the other side, in this case, the Deputy President, to seek legal advice, to give instructions on how best to respond to it. And this Honorable House has fixed 2 days for this trial. And one of the issues we'll be raising is these allegations, and you are going to go through them, against the Deputy President, suspicions, conclusions, on matters that were never referred to DCI in Kiambu Road, who are trained to investigate these matters. Nothing was referred to the Anti-Corruption Commission or any of the other investigative agencies, including money laundering. We strongly object and ask that the record of this Honorable House reflects that if this is permitted for the National Assembly to call witnesses at this stage without first furnishing us with their witness statement and affidavits, the case of the Deputy President will be irredeemably prejudiced. So we object very strongly to that application.
Senior Counsel Paul Mwite, are you in receipt of the document now?
Mheshimiwa Speaker, this document, we are seeing it for the first time now, 3-4 minutes ago. And it has got many, many pages, so we were quickly going through it, and in order to save the time of this Honorable House, perhaps you can give us an opportunity to go through these documents, because we need to go through them inaonekana kama hii ni ukarabati. But let's go through it. Perhaps if you agree, Mheshimiwa Speaker, perhaps we can get on with the first prosecution witness giving evidence, and as soon as we've gone through this, then we shall come back to you, Mheshimiwa Speaker.
Thank you for your wisdom, Senior Counsel. Now, the other limb that has been raised is on the issue of summons to witnesses. Now, if you look at our rules of procedure, more particularly rule number 10, which provide as follows, that the Senate may, at the request of the National Assembly or the President, and in this particular matter, the Deputy President, invite or summon any person to appear and give evidence before the Senate. So the summons that have been sought are in line with the spirit of Rule 10 of our Rules of Procedure. You may attack the evidence when these particular witnesses who have been summoned, if their evidence introduces other allegations, then at that particular juncture, the legal team from the Deputy President, you may raise an issue, and I'll certainly hear you at that juncture.
Permit me, Mheshimiwa Speaker, to place it on record that the rules of this Honorable Senate must and have to be respected. But even above respecting the rules of this Honorable House, our Constitution has to be respected. Article 50, the right to a fair trial, which in terms of Article 25C, Mheshimiwa Speaker, you will remember, you are aware, that is a right that cannot be compromised in any manner. There has been no explanation why the EACC was never asked to investigate the allegations before they were tabled before the National Assembly and before a decision was taken, because the National Assembly cannot investigate criminal offenses. In fact, in implementing Chapter 6 of the Constitution, the Act of Parliament said a conviction is necessary. And now you want to reverse the will of the Kenyan people in electing the Deputy President without him being reported or the matter being investigated or him being convicted.